want to get straight to morning tea? Okay, so what we're doing this morning finally is we're just going to ask you first, is there anything that you found confusing as you've been working through the modules that you would like to talk about today? So we can sort of flag that. We're going to talk about the family dispute resolution system, so the different processes for helping our people, our family law clients, resolve any issues and disputes, and how mediation fits in to all of that, and a very basic introduction to what we call a facilitative mediation model, which is the model that we're going to be learning about in this course, and we will learn about that in more detail later on. We get time for morning tea, which is very important. Then we go on to the legal framework about children, so the parenting law, the relevant sections in the Family Law Act, and then how do family courts make decisions regarding children. Then we will look at conflict and underlying causes of conflict when we're analysing disputes, which will be particularly helpful when we get up to our intake module about gathering initial information from our parties, assessing whether mediation is suitable, and if so, how will we structure it and what the issues are. So firstly, I just wanted to ask you, was there anything you particularly wanted to talk about in those topics today? Was there anything that you haven't understood or you just wanted to focus on today? Or does that sound fairly okay? Okay, no one had anything in particular? Very easily pleased? Oh, that's good. Okay. So, and Patricia, was that PowerPoint still up or should I just open it again?
It's still up, it's just on the outside system.
Do I just go up here? Yep. Oh, thanks. Thanks very much. Okay, so we'll start off looking at this family dispute resolution system. And I guess the reasoning is to sort of give you a bit of an idea of what's out there, because you're working in the family dispute resolution system, you've probably got a bit of an idea anyway, and you might know about things that I don't know about in terms of what some of the services are available for people. So if at any time you've got a question or want to add anything, just let me know. We'll also have a look, apart from some of the processes that people can use to help them sort out issues between them, we'll have a look at the basic legal requirements in relation to dispute resolution in family law, and we're just going to focus on the requirements in children's cases this morning. We'll do property and financial cases later. And we'll also look at the roles of some of the different participants in the system, such as family dispute resolution practitioners, which you will be eventually when you finish the course and become accredited, family lawyers, what we call independent children's lawyers, counsellors, which some of you probably have counselling backgrounds and know all about that, and also people that we call family consultants and what they do. Oh, that doesn't work. Hang on, I just have to work out how to click. Do I click that? Work? Yep. Oh, yeah. Okay, so when we talk about the family dispute resolution system, what I'm referring to is all the different processes that can help our legal aid clients sort out their problems. So it's in the context generally when people have separated, they need to come to agreements about their children and property, and sometimes they can't reach agreement. So we have courts, we have tribunals, and actually I should really have it around the other way, shouldn't I? Because generally, hopefully people would access these sorts of places first before they go anywhere near courts. But we have courts, tribunals, we have mediation outside of court, such as here at Relationships Australia, and then we have a whole lot of different places that people might go for different issues, such as Child Support Agency, Centrelink. And in family law, we do have it sort of a bit complex in relation to the law, because we have Commonwealth law and state law, and then Commonwealth courts and state courts. So it's to give you sort of a little bit of background about that. So remember, at any time if you've got a question, let me know. Okay? So have people heard of that we've got the family court, but we've also got the Federal Circuit Court. So many years ago we just had the family court, and it was much simpler and easier. And then the federal government had the great idea of having another court. The Federal Circuit Court just doesn't do family law work, it also does other federal cases such as immigration and bankruptcy, but most of its work, surprise, is family law. The Federal Circuit Court High do most of the family law work now. They do all applications for divorce. So divorce applications are quite separate to other types of applications. Hi, how are you? Divorce applications only deal with married people have separated for 12 months, make an application for divorce. It's quite separate to any other applications in relation to children or property. So the Federal Circuit Court does all divorce, most parenting and property applications. So say if you're talking to people that are in court, they will generally be in the Federal Circuit Court. The family court do more complex cases. For example, very complex property cases where people have complicated financial structures, for example. Also, they do what are called Hague Convention cases. Have you heard of Hague Convention? So, international abduction cases. For example, we've just had that case, was it the 60 Minutes case, where the mother was trying to sort of kidnap her children back from Lebanon. They also do what are called Magellan cases. Has anyone heard of Magellan? Which are where there are allegations of serious, and I guess all allegations are serious, but unfortunately in the family courts they have a lot of allegations, but serious allegations of sexual abuse go to what's called the Magellan list.
So what makes it a serious allegation as opposed to just an allegation?
Good question. I guess that is a good question, actually.
Is evidence substantiated?
Yeah, well, I guess, and often people would have had involvement. Say people would have had past involvement, for example, with the Department of Child Safety. They might have had involvement with police. There might be medical reports, that type So, I guess in the court system, people refer to allegations, and then it's only at like a contested trial that the court decides whether, and being quite technical, the family court actually doesn't even have to make findings that sexual abuse has occurred. But I guess it's a more complex case too. So when family courts are dealing with allegations of sexual abuse, it's not like a child protection case in a state court. It's in the context of parenting orders. So the family court's working out what parenting orders to make for children. Does that make sense? Yeah. Now the state courts are our state magistrates courts. They do a little bit of family law work, but generally in the outer suburbs and in country areas, family lawyers might take applications to a state magistrates court, but they can't have contested hearings in family law. That's children and property. They can also do consent orders where people reach agreement and they want to file a consent order. What they do a lot of is domestic violence applications, which are called applications for protection orders. They also have in Queensland, we have a children's court section of the magistrates court, and that does what we call child protection applications. Now they're quite different to what goes to the family court. Generally, family court cases are between parents, generally. Sometimes they can involve grandparents, other relatives. But child protection cases are between the Department of, big long name, Communities, Child Safety and Disability Services, and I just call them Department of Child Safety because that takes too long to say. But the difference with a child protection case is the department is making the application, so it's quite different to a family court case. So the department, if they go to court, will make an application, or even before they go to court, they might initiate investigations and sort of involvement with families. They try and negotiate agreements. For example, they might be supervising a family where they've got concerns about a child, and then they end up going to court if they can't work things out to be able to make satisfactory arrangements for a child. The worst case scenario being that the child's removed from their parent or family and placed in foster care. But before that, the department, if possible, will be trying to say supervise and get parents into parenting programs and all this sort of stuff before they might take that sort of action if possible. So any questions about that complex system? It does cause problems in that some of our families can have domestic violence orders, child protection issues, plus be in the family court. So it's quite splintered. And there have been arguments for a unified family court, which I think they have in some other countries, but it's really because of our constitution and our legal system that's quite complicated.
Would there be different court trials then in that case?
Sorry?
There'd be different court trials then in that case?
Yes, definitely. Like, say for example, if you had a contested domestic violence hearing, that happens in the magistrates court. If you have a contested parenting hearing, that happens in the family court.
What does contested mean?
Contested means people haven't reached agreement.
Okay.
So
some would require that, for example, the magistrates court rules before parenting orders or anything made and things like that.
it doesn't necessarily have to happen in that order. You could file a domestic violence application and it not be finally heard before your parenting matter. The one area though is child protection. If there is a child protection order over children, the family court doesn't really have any power to make orders. So say for example, the department have become concerned about a child, they've made a child protection order. The family court doesn't really have any jurisdiction to deal with that child unless they get the consent of the department and all that type of stuff.
What if there's a parenting order in place and then say a year later there's a child protection order? Does the child protection order override the parenting order that was made, like say previously?
It would, unless it can be consistent. So say for example, if the child protection order is about, say, concerns about dad, and mum's got the children, and she can, and I guess it might mean that the family court order has to be amended. So, but it certainly provides.
Because what if the child's with the primary carer is the person that the child protection order is against?
Yeah, definitely.
Then that child is like left in limbo because they can't be with the other parent because the parenting order is made, and then the primary carers. I've just had that situation, so I was just kind of seeing that would.
Yeah, definitely the child protection order has got the priority.
Yeah.
So, say in that scenario, the child protection order overrides.
Yeah.
So if the child protection order said that the live with parent is now not able to live with in the time with care, then that would probably outrule the parent order.
Yeah.
It definitely does.
Yeah.
And there's actually a section in the Family Law Act that says to that effect, that anything that happens in child protection overrides family law.
So can you take, say, a domestic violence order from state court and use it in family court?
It is relevant. So once you've got a domestic violence order, if you then, say you then make an application in the family court, or even if you've got proceedings in the family court, you have to let the family court know.
Mm-hmm. So whatever, the orders can go across the court.
Yes, my understanding is they don't automatically go across, but the person that obtained the order has to file a notice of violence. So it was like a Form 4 notice of abuse, notice of family violence, and they should provide the copy.
Right,
So,
okay.
and any findings made in the domestic violence court, if it is a final hearing in the domestic violence court, they do make a determination about whether domestic violence occurred, and then that's relevant to the family court proceedings.
So what happens if the domestic violence orders are put in place after the court order? Because we always get that there's court orders and domestic violence orders, and the court orders overrule domestic violence orders. So then, if the child was at risk, would the parent just keep the child and would have to show that they were acting protectively with a contravention?
Well, the domestic violence orders, and there's different types of orders. There's a temporary order, there's a final order, and then there's a consent order, sometimes made without admission. The final order is usually meant that the magistrate's made findings that domestic violence has occurred. Temporary order, they might not have been able to do that, but they've made a protective temporary order. Consent order is often made without admission. So a consent order without admission means that the perpetrator of violence has consented, but they've said that they haven't actually committed the acts of violence. So all of that's quite technical. So I guess something to be aware of too is that sometimes people do make applications for particular strategic reasons, and you know, there are a lot of very genuine applications made, and we know that there's a lot of research out there that shows us that there's an awful lot of violence, but there are some people that make applications when they don't have the evidence to support it, not meaning that it hasn't happened, or sometimes it hasn't happened. So I guess the fact that someone's got a consent without admission order may or may not mean that domestic violence has occurred. Does that make sense? It's very messy. So generally, a domestic violence order won't stop a parent seeing children unless there are concerns that one, the domestic violence has been committed against the children, or two, that the exposure to violence is so serious that it's not beneficial for the children to have contact. So just the fact of a protection order doesn't mean children can't see their parent.
So would the children's names need to be included on the protection order then?
Children's names can be included on the protection order if there is grounds for that. So they're called named persons then on the order. But that again doesn't stop them seeing their parent unless there's something specifically on the order, because normally it just says does not the respondent be of good behaviour and not commit domestic violence against blah and the named persons. Now that just means that they're to behave appropriately. It doesn't stop them having any contact unless there's specific contact, no contact provisions. It's really, I guess magistrates can make temporary orders saying that children can't see a parent. I haven't actually seen it happen. It can happen, but it's really considered that it's the family court. When we talk about family court, we mean Federal Circuit Court. Family court's place to make those decisions, not the magistrates. So if a magistrate did make something like that, it would be temporary, pending the family court actually. The reason being that people often go to extreme measures to stop parents seeing children, and it's just not possible to let them go off to magistrates court and get those orders lightly, because often they've got a whole lot of reasons why they don't want people to see children.
So the child would have to be named specifically in that order?
They'd have to be named specifically, and there'd have to be a specific provision in there saying that they can't come into contact with that person. Because just to be a named person doesn't mean they can't come into contact with their parent, because it just means they've got to be of good behaviour and not commit domestic violence against them. Yeah, does that make sense? I know that's all quite technical, but and it's quite common. Say for the legal aid conferences that I mediate, it's very common for there to be family protection orders. Very common. And often protection orders against each other. Often people will have orders against each other.
Yes, I've heard that.
The other thing, and you might be familiar with child support, would you get any queries about child support for you frail people? It's a very emotive issue for people. When you're working in family law, it's often more emotional than the time people spend with their children is how much money they pay. Some people go to very extreme lengths not to pay anybody. For example, they quit their job or they work for cash. I've even had a friend who used to work as a child support review officer that used to do telephone conferences, and she'd be ringing, say, for example, a father, and he wasn't able to pay child support, but he's actually given his work number to her for the conference link up when he's not working, so stuff like that. So child support's different in that it's an administrative assessment initially. So people can make their own agreements. So they either make their own agreement or they go off to the child support agency, they file some forms, and it's an administrative assessment based on a formula. Then they can, if they have grounds, they can do an internal review if they're not happy with the decision, but at a higher level it goes to the Social Security Appeals Tribunal. So just be aware that's different to a court application. Okay, so in terms of the different processes that we've got available for our family law clients, some of these have gone a bit haywire, but there are a whole lot of different processes that people can use if they've got issues, and the most common ones are about children, and then probably the next common ones are about property and financial stuff. So we talk about this spectrum in terms of how much it costs and how complicated it is, as opposed to how little it costs, how less complicated it might be and the extent to which people get to make their own decisions. So I guess here would be, and in terms of negotiation too, people talking together and working it out themselves is a negotiation. Or people not being able to work it out themselves, but they might get lawyers to talk together and work it out for them. At the other end of the spectrum is going to court, which, and a lot of people now go to court without lawyers. We call them self-represented people. But it can be a lot more difficult for them. The courts, even though the family courts have become a bit less complicated, they're still quite difficult for people, particularly when people are upset and angry. Sometimes in family law they can be quite emotional,